So, but the thing is this though, with radon, when you're doing an appraisal with a piece of property, and it has radon, what are you gonna do with that information? Are you gonna find out whether it's abated? Are you gonna find out whether it's under control? Are you gonna find out whether the levels are what's acceptable or not? What do any of you do when you have radon? What do you do, Chuck?
Well, one of the things is you find out about whether it's been remediated, what levels, what is the cost of remediation? Will a simple fan help, or is it more complicated? Is it naturally occurring, or is it from some other source?
And the thing is, what's interesting about radon too, this is one thing you should keep in mind, by the way. This is a very interesting little thing to know, and at some point in time it may become more prominent in terms of what you do with this. We're really starting to understand radon now. Radon's only been monitored and evaluated for, 10, 15 years now. Before then, nobody talked about it. And the Environmental Protection Agency set a standard for radon. And basically, it's a standard that indicates how much radon gas can be in the living space of the house before which remediation is required. The way you handle radon is one of two ways. You could either vent it out passively,
Right.
which is, or you could get a high-tech fan, and that's if it's not working by just venting it out. Or as one guy said, you could just open a window. So that's sort of the idea. You're getting it out. You're getting it out of the living space. But here's what I want you to know: when the EPA set the standard for, and we've talked to people who worked at the EPA when the standard was set and were involved with the program. When the EPA set the standard, they were looking at minors and the impact to minors based on a certain risk. Not people living in a house, not children living in a house. And a lot of people really question that standard. Also, toxicologists will always tell you that 4 is the level that's acceptable. But if you have 3.8, it's not time to break out the champagne. It's bad stuff, and you still have a materially greater risk of getting a bad disease if you have radon in there. And nobody really knows when that risk becomes important or not. But just because, the key with radon is always get it down as far as you can. Don't think that any particular arbitrary standard is safe. Radon, you really want to get down as far as you can. They don't know what's safe and what's not. And many people will tell you that standard that the EPA set is really arbitrary.
Well, I think a lot to do with that standard, and it's the same with a lot of other environmental contaminants, was how far you could practically remediate it down to. That was another issue with radon when it first came out, that 4 picocuries per liter is the standard, but they said essentially getting it below 2 at that time was almost impossible.
That's right.
And now they have some more high-tech stuff, and it's similar with a lot of other contaminants. But
so keep that in mind when you're looking at houses that have radon, and recognize that just because they got it at 4, right now, probably you're going to say it's under what's acceptable, so it's okay. But that might change. Keep your eyes on that. I think the science is changing. I think what the scientists are saying will change. And you may have to sort of readjust your way of thinking about that. That's what I would say. Let's go to the next one over here. Contents of disclosure. This is basically what you're going to have in your expert report. What you're going to have in your expert report is effectively a logical, concise explanation of what your opinion is and how you got there.
Right.
That's the easiest way to say it.
That's right.
A logical, concise, understandable explanation of what your opinion is and how you got there.
An interesting thing actually about the federal rules, at least interesting for us, is unlike New Jersey, you actually have to make a statement about how much you're getting paid, or effectively how much you're getting paid to do the expert report.
Wait, you're supposed to pay them? Oh, yeah.
Anyway.
You know, when you're deposed, so after you give your expert report, you'll be deposed. And that a deposition is where there's a court reporter and a machine, and they're taking down everything word for word, and they're asking you questions about your report. And don't you know, the attorney for the other side will almost invariably ask you this unbelievable strategic question. It's brilliant. Are you getting paid to be here? As if it's a big surprise, you know, and as if you're biased just because you're being paid. So there's a stigma, if you will, attached with experts being paid, but there really isn't. I mean, everybody obviously understands you're being paid, and just because you're paid doesn't mean you're making up your testimony to suit the wishes of the attorney that retained you, you know. But they will very often ask you that ridiculous question. Yes, sir. Yes, I am. Of course I am. I'm a professional. I'm paid to be here, and it had nothing to do with my testimony.
My answer would have been not enough.
That is one of the answers that people throw at you. Yeah. When I ask the question, that's what they usually say. Not enough. No, but it's a ridiculous question. It's a stupid question, you know. And we have enough stupid questions out there. They could at least get rid of that one. If your report isn't sufficient, some courts will throw it out. That's the next slide. I mean, certain courts have minimum requirements, but that's not your problem. That's the lawyer's problem that retains you. The lawyer needs to make sure that the report has the requirements. You shouldn't worry about that. That's not your job. You didn't go to law school. Some of you did. But I mean, you know, you're not here because you went to law school and you're a licensed lawyer. You're here because you are licensed as an appraiser and you have your credentials and experience as an appraiser. That's what you have to worry about. So you don't have to worry about that. Okay, so then there's also these other rules called the rules of evidence. And the rules of evidence describe how we get things before a jury and what a jury can consider, or what a judge consider if there is no jury, in making a final decision in terms of what the facts are. Just the basics, the real basics of the thing is this. Court is divided up into two different tasks. One is understanding what the law is, and the other is figuring out what the facts were, right? That's it. That's all there is in court. There's two things always, every single case, from the first case with Abraham and whatever, and till today. That's all there ever is. Two things are decided. What's the law? What's the law that applies? And what are the facts in the case, right? The judge decides and helps everybody with the law. That's a legal thing, and the judge does that part. And you really have nothing to do with that, too. That's up to the judge. The lawyers might argue about what law should apply, because sometimes there's competing laws that might apply. But that's not going to be your deal. You don't have to worry. But you're part of the fact thing. That's where you fit in. And the jury has the exclusive responsibility of figuring out what the facts are, making a determination as to what the facts are. Now, there's a difference between the real-life version of the facts and the facts that the jury decides, because in real life, the facts might be one thing, but in court, the facts are going to be governed by what evidence got in, what evidence didn't get in through this process that's somewhat limited by these rules of evidence, and then what they all decide when the door is closed and they are trying to reach a verdict. That's the fact. So often there's a difference between the fact in the objective sense, you know, if you were just a fly on the wall and you saw really what happened, and then the facts determined by the jury. But it's the jury's responsibility. Your expert report helps with the facts. How much was the diminution? That's a factual issue. That's a fact. How much is the stigma, or how much are the damages because of this pollution? You know, these are all things that you help with, but they're factual issues, and they go to the jury, and that's what it is. These rules describe that. Now, there's a difference in court, all courts, state court, federal court, in all 50 states and Louisiana. There's a difference between lay testimony and expert testimony. Lay testimony is testimony with people who aren't experts. You know, people who saw something, people that witnessed something. In a car accident case, guy who saw the car go through the intersection right before the collision, you know. That's a lay testimony, just some poor guy that was there, or, you know, in an environmental case, you might take testimony from the contractors that are doing the cleanup, just to show how many buckets of dirty dirt they took out. They're not there to provide expert, they're not there to opine as to anything. They're there to just tell the jury what happened, what really happened. That's a fact witnesses. They're fact witnesses. That's what they're there for. And they're really an important part of a case, because you need to explain to a jury or judge what happened. You know, how did we get here? Why are we here? You got to tell a story. Those are fact witnesses. You're not generally going to be hired to be a fact witness. It happens sometimes, but you're not going to generally be hired to be. You're going to be hired to be an expert witness.